Good afternoon, everybody. We're going to talk about wage replacement and indemnity benefits. And before we do, I have to read these following messages. This is for instructional purposes only. It is not advice as to any particular matter. This is for CLE credit, transitional 1 hour of professional development credit. To comply with our requirements, you got to put away your devices and pay attention. After the presentation, you have to rate me. All right, goals for today. In front of you is a handout. I also put this in Teams. We're going to try to talk about a little bit of a higher level discussion of indemnity today. And when I was doing research for this, I came across this awesome decision that someone in our office, who I will name, got that was based on a post-classification challenge to attachment, which is kind of fun. So I want to talk about that today. In your handout today is a lot of things that I'm not going to have a chance to get to. Sections 14, 15, 16, which are how average weekly wage is established, using your multiples. I'm just going to presume we all already know that, and we're going to skip through that pretty quickly. I'm expecting everyone to be familiar with Section 15, specifically subsection 3, V, and W. We're going to be talking about them a lot today, so let's get excited. We want to talk about loss of wage earning capacity. I am going to shoehorn it into this discussion of indemnity. And then I did put in the regulations, 300.23, which is the regulation that concerns us when we are reducing or suspending an indemnity benefit. And this is kind of in conjunction as well with the new RFAs that are going to be coming out in 2 weeks. Raise your hand if you already took the new RFA training. What? That's great. Okay, about half the room. I have not taken it yet. I plan on taking it on the 10th. It's also going to be offered now on the 18th, so there's going to be a couple opportunities. And we're going to be figuring out how to challenge awards with the new RFA process, because there are going to be, if you took that training, some challenges, including being named a party of interest in order to file that RFA. So there's going to be some new things. There's also some recent board decisions, and one in particular I'm going to talk about that discusses the board's requirements under Section 300.23. Did everybody know that when you file a RFA2 to reduce or suspend an award, the board is supposed to list that for a hearing within 20 days? Do they ever? No. Well, there's now appellate decision that says, oh, that's cute that the board has to do that within 20 days, but no, they don't. They don't have to follow their own regulations. So that's kind of crazy, and it doesn't help us, particularly with the implementation of the new RFAs. And then I put some quick summaries of the case law that has developed in this area over the last 2 years. We're going to go through some of the new cases. And then I also put a separate handout, which is just all of the case law that's happened in the last 2 years. For those of you who, maybe you have trouble falling asleep at night, or maybe, you just had, Valentine's Day and your significant other loves talking about suspension or temporary abatement of awards. And that's kind of fun stuff. All right. Then my goal is to talk about what we're going to do to be proactive in our cases, how we can kind of take this dry topic and use it to create some leverage in our cases. And in the middle of your handout, there should be a full reprint of a wonderful piece of case law. I believe the case is Alexis Cintron's case. It's a Nebraska land case, and we're going to go through the case. What's the name? I don't know the name of the first name of the claimant. I forgot it. Daniel Martinez. All right, so after this meeting, we'll circulate the file number in our office so you can read the wonderful briefing that was done on this case. And then at the end, I want us to have a discussion. And so as we talk about how we're going to suspend or challenge awards, how we're going to suspend or challenge temporary partial disability awards, temporary total awards, and LWECs, we're going to go through an exercise, and I'm going to challenge everyone. And we're going to go through a whole bunch of different fact scenarios and just think about what would be our best, most proactive argument to suspend or challenge awards, both temporary total, temporary partial, and then even post-classification awards. Okay, so those are my goals today. Now, some of this stuff is a little bit on the edge. You're not going to find a lot of case law about challenging post-classification awards. I think this is an area where we could make some interesting case law. We can't do worse than what the board did, what the legislature did in 2017 when they amended Section 15 to add subsection W and take away our labor market attachment and classification cases. But again, I'll talk about that when we get there. But I think that's going to be the interesting part of what we're doing. Maybe just to me because I'm a nerd, but I'm going to hopefully try to get other people excited in this idea as well. All right. So how does this fit into our worldview? Well, generally, I think if you're challenging or trying to suspend awards, you're probably litigating your case. The other opportunity is you've got a fact defense, right? Because you raise fraud in order to suspend or reduce an award. Applying it to our indemnity benefits, our goal is to have some sort of tactical action in every single case that's going to drive or create some leverage in our matter. In this instance, we're attacking money. Now, statistically, if you read the board's latest report of cases, only 14% of cases are 5 years of duration or longer. Only 14%. But it feels like in our office, it's more like 30% of the cases we're defending have been kicking around for a long time. And those are the cases that we should be focusing on. How can we challenge money benefits? Because that's what's going to lead to case closure. All right, let's talk quickly. I'm going to go very fast through the stuff that you guys already know really well. And then I want to get talking about what I think are the interesting things, attachment, lack of causal wage loss, and then how we attacked a post-classification award and when we should attack a post-classification award. I believe we do need to be very aggressive, particularly when money is flowing to the claimant. I also believe very strongly that's what drives these cases. We know we are in a passenger situation. We're not the driver of this ship, right? The driver of the ship is the claimant who can choose their own terrible physicians, who can delay their own treatment, who can be out of work for 2 years and then decide maybe someday they're going to get the surgery. All of that stuff is working against us, which is why we have to really bring our energy and attention to these cases to get some movement in them. Couple scenarios we're going to talk about before I talk about classification. We have to handle cases differently depending on whether the claimant is currently temporarily totally disabled or partially disabled. The temporary total disability cases, essentially they are claiming they can't work. They usually have 100% medical from their doctors. I don't think we see very frequently doctors not temp totaling people forever, and they will do it forever. The challenge, of course, is that you could be temp total forever for the rest of your life and never get a cap start running. And this is a very bizarre component of this jurisdiction. I'm not aware of other jurisdictions that say you can be temporarily disabled forever. It's just a crazy thing. And again, it puts the burden on us to bring our energy to these cases and find the reasons to challenge that. Every year, we know the maximum benefit, which is pegged to the state average weekly wage, goes up, which means the indemnity exposures in cases go up. If you wonder what keeps the CEOs and the CEOs and the CFOs of all the companies that we serve up at night is the fact that this is relatively outside of their control, that even if they are just as safe next year as they are this year, their exposures are going to rise simply because the state average weekly wage is going to rise, and we're going to keep seeing these increases in awards. What's going to happen in July is the minimum rate is now going to be pegged to the state average weekly wage. Okay, so that will be the first time that's ever happened in workers' compensation history in New York. This is part of the reforms that phased in 4 years ago. And I can tell you that just based on what the current state average weekly wage has been calculated at, you can expect the minimum rate to go up to about $380 in July. Okay, which is kind of crazy because if you think about it, only 4 or 5 years ago, that minimum rate was $150. So that's really going to increase exposure across the board. All right, so their temp total, we've got to do something. What do? We have to challenge what their physician is saying. We've got to look through the medicals carefully. This is where our paraprofessionals are wonderful. Look for that return as needed. Look for that medical plateau, even if you don't see it. They don't say maximum medical improvement, but if the condition's not improving, we can make an argument that there are constructively maximum medical improvements. Now, this is also important for another reason, beyond just maybe getting a temporary reduction. It also gets your 130-week cap running under Section 13W. 15.3W, right? And we want to get that cap running. How do we challenge this? Well, we take their physician, put them on the stand, we cross-examine them. Maybe their medical goes stale. That's an opportunity for a suspension. We can show unrelated wage loss. Hey, the reason that they're not working is no longer the workers' comp case. They're actually out of work now because they have a pregnancy, because they've had a car accident and they're treating for that, or some other reason. And of course, it's always an opportunity to raise fraud. That's a great opportunity for us to suspend or reduce benefits. There's another opportunity for us too when the person's been separated from the employment. I know the claimants will allege, well, I'm still a member of the union, so I haven't really been separated from the employment. But whenever they have been, and look for those for-cause separations as well, that's an opportunity for us to challenge wage loss and argue, hey, it's no longer related solely to the workers' compensation incident. Maybe now it's related to something else. Okay, so that's stuff we already do. How do we actually effectively raise this issue? It is by filing the RFA. In the past, I would walk through, okay, it's box A, it's box B, but if you've already taken the new RFA training, you realize you're just going to be clicking buttons on a board form. Most of the buttons are going to be the ones on the top, which are 300.23. That's the regulation that governs suspension or reduction in an award. Okay. Now, interestingly, in Section 300.23, which is the part of the rules that allows us to force the judge to address this issue and reduce or suspend an award, says the board must list the case for a hearing within 20 days. But the appellate division just came back and said, well, we know the board never does that, and we're not going to hold it to them. And that decision just came out in May of 2025. So as frustrating as the new RFA process is going to be, I don't see that this is the reason why the board has no interest in actually scheduling your hearings within 20 days. All right. It's a challenge, but again, this is what we need to do. If the claimant is less than totally disabled, we've got way more options, right? And you're now firmly in your L bucket of things to be doing with your case. Those options are, hey, can we give them a light duty opportunity? Can we argue that they're no longer attached, right? Can we force them to look for work within their restrictions? Okay. Is their medical up to date? All of the basics that we can use to try to force them. I love it when the claimant's less than totally disabled because it gives us a lot more stuff we can do in our cases to bring them to the table and to challenge those ongoing benefits. Everyone knows what labor market attachment is. It's been redefined to be more than just looking for a job. It's also signing up for rehabilitation or vocational courses or signing up through the web app to get some help with your resume. And I think claimants are very, very astute figuring out how to demonstrate attachment, how to fill out those C-258 forms, and how to try to prove that they are looking for a job. All right. Now, let's talk about one of our cases, Sanchez versus Baldor. This is a case in which the claimant actually gets on the stand, and this is an attachment case. And our argument essentially is, hey, sure, they're attached, but is she even going to accept any offers that she got? The claimant gets on the stand. The claimant says, look, I sent out 60 resumes. I filled out all these applications. I went to all these interviews, but then admits during cross-examination, well, actually, even if I got a job within my restrictions, I wouldn't take it anyway because I'm in so much pain. Great, done, game, set, match. Yeah, that is not labor market attachment. Even though she went through all of the effort of filing all those job applications, completing all those forms, et cetera. When she said on the stand, oh, even if I got a job, I don't think I could take it because I'm in so much pain. You've now said I am no longer attached. So you have a case where, a C-258 comes in. It looks like they've applied for 100 jobs on Indeed. Still valuable to take their testimony, still valuable to ask them those questions. All right, well, if, and ask them the hypothetical question. This is what I'm asking you to do. If you got this job, I know you didn't, but if you did, would you have shown up? Would you have appeared? And maybe they'll tell you the truth. And in this case, she did. She said, I wouldn't accept it even if it was within my restrictions because I still feel like I'm in too much pain to do any work. Well, that's not what your doctors say. And so the board, the appellate division came back and said, sorry, that's not attachment. Yover versus Alba. This is an attachment case in which he applied for all sorts of jobs that he had absolutely no qualifications for. This is the claimant who did not speak English, didn't have any of the education that was necessary for any of those jobs, put him on the stand and admits, yeah, I actually wasn't qualified for any of these positions. That's a great attachment argument, that case that you can prevail in. Claimant's proofs. This case, trade winds, is not good for us, but I thought it'd be one for us to discuss because it's relatively recent. This gentleman submits evidence showing 600 pages of evidence showing that he applied for all sorts of positions: dishwasher, doorman, cook, parking garage attendant, kitchen attendant, helper, juice maker, juice barista, laundry attendant. He applied for all of these jobs, but he didn't get a single interview. So the carrier comes forward and says, well, it's cool that you applied for 600 jobs or 600 pages of jobs, but no interviews mean you must be doing something wrong. The appellate division said, well, he did apply for a lot of jobs. He can't control whether or not he got the interviews. So they did find him to be attached. I still think we should make that argument all day long. You're really applying to 600 pages of jobs. You don't get a single callback. Something is going wrong here. But maybe you've applied with the wrong phone number or something. So even though, the appellate division didn't rule, I think is favorable to us, I still think this is an argument. This is a fight that you've got to pick. The other, in this case, is there's a very interesting dissent. And the dissenting opinion said, well, it's cool. Okay, jobs that he applied for. But all of these pages were in Spanish, not English. And none of these jobs had any job descriptions of the work that he would be doing. So it's impossible for us to know if these were actually within his medical restrictions or not. And it's impossible to actually vet what these jobs are for because this is in a foreign language. Okay. I think that's a very important point. Even though, again, this is not a favorable case for us, I think the dissent gives us some instructions as to what to do. If you are getting C-258s or Indeed postings and it's in a foreign language, we're not interpreters and we shouldn't accept that. We should say, okay, well, you've got to go get this interpreted and then applied and then submit it to the board. We do not conduct and we don't litigate in any other language other than English. And I should probably repeat this. In the past, I haven't seen this in a long time. I just saw it actually last week, but in New Jersey, not New York. I got an affidavit of settlement, like a Section 32 addendum, in which each paragraph was written out in English and then in Spanish, and then in English, and then in Spanish. I don't read Spanish. I'm not signing anything that I can't read. Okay, you could say that this is a great translation of it, but I don't like that. I'm not signing that. I said, submit one in English and you can have an interpreter present to read it to them on the record when we put the case through. We should not be relying on any proofs in any language other than English ever under any circumstances. All right, same thing when you're going to suspend temp benefits. Same game. We've got to file this new RFA2 form. It's going to be one of the two top boxes generally, unless it's fraud, in which you'll be alleging fraud at the bottom. All right. LWEC. This is my last little point to make here. Once someone is classified and attached at the time of classification, we can't raise LMA again, right? We're all comfortable. We all understand that. Now, we used to be able to, before 2017, clients would send us cases where the claimant was already had an LWEC established, and then we'd say, cool, we're going to go fight with them. And we would raise LMA and say, well, you're classified, but you still need to show constant proofs of attachment. Of course, nobody wants to do that. They're nice, they're relaxing, they're retired. And then we would be able to Section 32 the case. So the point of attacking a classification after the classification has been established, adjudicated, consented to, even when you settle or stipulate to one, you could then try to raise LMA. We used to be able to do that all the time. 2017, they changed the law. We're not allowed to do that anymore. All right. But is it really gone? All right. So what Section 15 is, it's a compensation under this paragraph. Okay, this is LWEC classification, shall be paid continuance of partial disability without the necessity for the claimant who's entitled to benefits at the time of classification to demonstrate ongoing attachment to the labor market. Okay, this is what they amended the statute in 2017 to say. All right, so what it means is if at the time of classification attached, we can't raise attachment anymore. Okay, everyone knows that. It's very sad, boo-hoo, not good for us as employers or carriers, good for the claimants. But this behooves us, or this is the impetus as to why every case, when they're being classified, you need to raise labor market attachment, okay? The only way to defeat this for them is, wait, I'm currently working. I'm working right now at the time of attachment, right? And you'll find case law that says, okay, cool, you're working at the time of attachment. we'll give you a reduced earnings award. That's going to establish that you are attached, and that attachment agreement goes away forever. There is very good case law, and the case name is Dig Bazanis, which says that once, if you prevail on attacking attachment at the time of permanency, you've now preserved that argument forever. You can consistently and constantly raise attachment forever. So it's like the 2017 amendment to the statute never happened, which puts a big tool back into your toolbox. Okay. Now, the other things we should be doing every time at the time of a classification, we can't do this for a SLU. We can't do this during temporary total or temporary partial, but the time of classification, that's to ask about the person's residency status. This is the time to make the argument that a resident alien is not eligible for an LWEC award, and there is case law that will stand for that proposition. So those two questions always have to happen at a classification, even a stipulated one. Okay, we should be asking, one, are you attached? How are you looking for an employment? That you should stop the proceedings. The judge should then direct them to send you LMA proofs. And the second thing you want to do is always ask about their residency status. It's not appropriate any other time in a case except for the time of classification. Okay, and that's the right time to ask that question. And if they say, well, I've got a green card, but it expired, great. You have a good, strong argument for the appellate division as to why you should not be giving them an LWEC award. All right. All right, but what can we still do where the claimant has demonstrated attachment at the time of classification? What can we still do post-classification to challenge their entitlement to an ongoing award? Again, assume attachment is found at classification. Well, there's nothing that stops us from arguing that future LWEC is unrelated to the workers' compensation case, okay? So the claimant who might be attached at the time of classification doesn't have to show doesn't have to show their labor market attachment efforts, but there is case law that stands for the proposition they can't then, for example, subsequently retire, okay, on purpose from the employment. Right? They can't do things to impair their own labor, their wage earning capacity after classification. Now, this is not going to be useful in very many cases at all. But in some cases it might be. And the kind of cases that I can tell you, and I'll specifically talk about the matter of Lawner versus Eurobrokers. This is a gentleman, this is a 9/11 claim. It's a PTSD 9/11 claim. He got a classification for PTSD. He worked for a number of years, continuing as a stockbroker. He then left the employment, started his own stock brokerage. He then left that stock brokerage, worked for another one, then he worked for a third one, then finally he just stopped working. And again, this is pre-caps. So he then brings his LWEC award, says, okay, now pay me for my PTSD case. And the defense in the case essentially said, that's cute, but no, you've voluntarily removed yourself from the workforce by no longer seeking work. So that's very interesting because they're saying it's unrelated wage loss. You're not working as a stockbroker and you chose not to. It's got nothing to do with your impairment. And they prevailed in that argument. Okay. Now, it is a pre-amendment decision, but I still think it's one that we could utilize. So if a client comes to you and a client comes to me and what can I do about a post-classification person who separated from employment, they've moved to industry, they've retired, they've taken a normal retirement. Okay. That would be another example. Post LWEC, still work for the same company, maybe in a reduced earning capacity. Your award's running, you're still under your cap, and you take a normal buyout. There's a great argument there that that classification should come to an end because they've taken there's some other unrelated wage loss reason why you're not working. Okay, so I think it's a rare thing that could happen, but when you start thinking about the really weird edge cases, it helps you, I think, sometimes understand how the statute is supposed to work. All right, so our discussion. In your handout, I've handed everybody a case, a wonderful decision in Nebraska land. And this is an example. Now, how many people in this room at classification have raised LMA and prevailed? Okay, 1, 2, 3, 4, okay. You have, this is your case. Okay, so yeah. You have. Okay. So you got a bunch of people have. All right. This is good. This is good. But some people haven't raised their hand, which is why I think this is an important thing to go through. All right. In this case, the Nebraska land case, the claimant was classified with a 75% loss of wage earning capacity, which is a pretty high finding of wage earning capacity. And during the pendency of the case, at certain times he was attached to the labor market and sometimes he wasn't. But at the time of classification, he was not attached. Okay, so wonderful, you're not attached, no awards are flowing. You got a 75% LWEC, which is entitling you to what, 450 weeks of compensation, but no money is flowing. What does he do? He appeals and said, this is unreasonable. The appellate division comes back and says, no, I'm sorry, if you're not attached at the time of classification, you got to keep showing these proofs. And in this case, the judge required him to show proofs of attachment every 60 days. So this is annoying to the claimant. And what this really does, in my opinion, is the point of challenging this at LMA and then challenging attachment at the time of classification is it gives you that opportunity for your Section 32, right? To go to the claimant and say, hey, you want to keep showing proofs every 60 days for the next 450 weeks, which by the way is almost 10 years? Or would you rather just lump sum this case out, right? So the goal here is not to win on these arguments as much as to just set the case up for this opportunity to bring it to a full and final for our client, right? That's the actual goal of raising these disputes. Okay. Now, that being said, let's have some fun. All right, I want to do this without calling. Well, maybe I will call on people. All right, I like to hear from the crowd because I've got a good crowd here. Let's go to the past the hypothetical. You should have a thing in there that has the same question that's up on the board. Okay, so here's my challenge to everyone. You've got a claimant entitled to temporary partial disability. Okay, presume the claimant has unrefuted evidence of a temporary partial disability and they have up-to-date medical. All right. Tell me what your best argument is going to be in this case to suspend, reduce, terminate benefits, create chaos for them so they want to come and settle their case against this employer. All right. Does everybody understand the game? You've got, Matt's looking at me quizzically. Okay. This is my challenge. You've got a claimant who has proof of temporary partial disability, strong medical proofs. Okay. They've got up-to-date medical. You're under a CCP. You're paying this person. Tell me, based on the facts I'm about to tell you of each one of these individual cases, what your strongest argument is, or if you have no argument. Is your strongest argument an attachment argument, a no causally related lost earnings argument? Because these are different things, right? An attachment argument is different than a no causally related lost time argument. Or do you have no argument? You just have to pay this person. Okay, so question one. Claimant works as an aerospace welder. The last plant that manufactured aerospace products closed in New York. The claimant has looked for a job as an aerospace welder, but has not been asked to interview or had any job offers. What's your best argument? Yes, Mr. Malone.
Argue attachment.
Okay, you would argue attachment. Anybody agree with that? Okay. All right. Why attachment versus causally related? No causally related lost earnings. Go ahead.
If the last plant that manufactured it closed in New York, what jobs is he applying to? Where is he applying? Can he travel out of state based on his temporary partial disability?
Okay, good argument. Good argument. All right. I think the better argument is no causally related lost earnings because general economic conditions are against him. He's not going to be, because the jobs don't exist anymore. Okay. And you'll find case law that says that person who's looking for a job in particular jobs like stevedore jobs that don't exist anymore, it doesn't matter if they look for jobs within that job description. If the job doesn't exist anymore, we can argue that general economic conditions prevent them from getting that position. It's a lot easier to make that argument, I think, than an LMA. But I think you could do maybe both, right? Maybe do them both. All right, next. Again, presume the claimant has unrefuted evidence of a temporary partial disability and up-to-date medical. The claimant retired from the job in 2018, taking a regular retirement at age 70. 7 years later, the claimant develops pleural effusions as a result of asbestos exposure and brought an occupational exposure claim. Okay, and again, presume that's within the statute. He brought the claim within 2 years of when he knew or should have known it was work-related. He has made no attempt to look for a job within his restrictions. What's your best argument here? I've scared everybody off. Christine. Attachment again. Okay. Anybody else for attachment? Okay. Yes, sir, mister. Agreed. Because he's already retired. He's already taken a voluntary retirement. It's impossible to now claim that his wage loss would be related to any other factor. That's why he's not working anymore. He took a regular retirement. Okay. And you should win 100% of the time on that. And by the way, attachment's not wrong. I'm just looking for what's the easiest or strongest argument, the one that the case law would easily affirm. All right, here we go. Here's another one. This is a trick one. This is a trick question. Claimant is arrested. Okay, remember, claimant has an unrefuted evidence of temporary partial disability and up-to-date medical. The claimant is arrested and incarcerated for committing burglary. While awaiting trial, he is receiving medical care through the jail system and continues to have up-to-date medical. What's your best argument for suspending or terminating? He's in jail. He is in jail. This is a trick question. I thought this would be a fun one. Scott, please.
I would argue attachment because he hasn't been convicted. So technically, because he hasn't been convicted of that felony, he's entitled to benefits potentially.
Okay.
I mean, obviously, I would also raise unrelated wage loss because you're not getting a job while you're in prison. But I mean, I'm assuming the trick part of the question was he has not been convicted.
Okay. That is the trick part of the question, that he has not been convicted yet. Okay. So I think that is going to be the right answer, but I also think we're going to be paying temp for a while until we can prove that. But yeah, yeah, I'm going to change my answer to that, to yours. I like yours. No labor market attachment. All right. Same question, kind of. I changed one fact. The claimant's arrested and incarcerated for committing burglary. After conviction at trial, he is receiving medical care through the jail system and has up-to-date medical. Kind of gave this one away. No causally related lost earnings. Okay. Next, claimant is worked as a laborer for the last 20 years and has no English speaking or writing skills. The claimant has shown proofs of attachment in Spanish, demonstrating he applied for 46 jobs, ranging from interpretive dance instructor to master electrician. What's our best argument? Attachment, I strongly agree. That's basically gave that one away. All right. Claimant has, this is me and Declan's case, by the way. This is one of my most sad fails. The claimant has worked as a skilled nurse. The chemical condition is reactive bronchitis related to latex exposure. The claimant has shown that there are no skilled nursing positions available within a 60-mile radius of her home that would not expose her to latex. What do we got? Attachment, not causally related. You got to pay her. Come on, someone from this back row. Wild guess. Go ahead. You think you got to pay her? Okay. Well, that's what the court said, but I think the court was wrong. I think the argument was attachment, right? And our position was, wait a second, she's a skilled nurse. Like, she could get a job reviewing medical records. She could be a paraprofessional. She could do 1,000 other things. She's only saying, I need to work in a medical facility. That was, that's my argument. All right. Presume the claimant has unrefuted evidence of temporary partial disability and up-to-date medical. Claimant testified that due to her childcare situation, she can only work 4 hours per day, even though the medical restrictions state she has a capacity for full-time sedentary work. Causal relationship. All right, the man in the hat from the back row. Okay. All right. Last one, and this is from case law that was just decided a few weeks ago, like 2 weeks ago. Construction accident involving a public employer. And in construction accidents or any accidents involving a public employer, the state, the government gets the right to do a 50H hearing within 90 days of the accident. 50H hearing is the claimant has to come in and testify about their injuries and their conditions, et cetera. So it's this rare opportunity where we get the testimony from the claimant early. In his 50H hearing, the claimant testified that he was laid off after the accident due to a lack of work. Best argument. No cause of related wage loss. Exactly. All right. Let's move on to our post-classification quiz bowl questions here. Presume your claimant, again, we're now in a post-classification world. These are not temporary disability questions. Presume the claimant has received an award of 60% loss of wage earning capacity and is currently receiving benefits. Okay, so they're inside the cap, but they're getting paid out under the within the cap. The claimant was not found to be attached at the time of classification. The claimant was subsequently found to be attached and payments began, although the claimant never returned to work. In other words, they showed proofs of looking for a job, but they never actually got a job. What's your best post-classification argument to create leverage in this case? Choices are labor market attachment, no cause-related lost earnings, keep paying it. Labor market attachment is correct. Okay, so let's not forget to do that and raise that to your clients. You know, you're closing a case and you're saying, hey, we got this finding of no labor market attachment. Don't close this case. Let us pick at this for a little while and see if we can get them to come to the table for a Section 30. Received an award of 60% loss of wage earning capacity and is receiving benefits. In this instance, the claimant was classified and received a reduced earnings award based on subsequent employment. He was then terminated from that subsequent employment. No causally related wage lost earnings. I think there's a Launer argument to be made here. And again, this is where we're going to get into some territory where you're not going to find any case law yet, but I think this would be a good one. All right, last question. Claimant returned to work following classification. Before the capped weeks were paid out, the claimant took a retirement buyout offered by his employer. NCLT says Mr. Kane, and he is correct. All right, some practical takeaways as we end this discussion. Yes, sir? You need to talk into your the cues.
Raising it. Is there a timing period? Or are you raising it before the judge comes out and says, hey, I'm fined 50%, I found 10%?
So post-classification, you probably are dealing with a case that's closed.
No, I'm talking about when you're raising LMA at LWAC, right?
Yes.
So are you raising, does it have to be raised before the judge says?
Yes, you
Okay,
have to raise it before the judge puts their impairment rating or severity ranking on this case. Otherwise, you have waived it forever. That's why it's one of our best practices to raise, you know, the two questions you got to ask is, Judge, can we want to raise labor market attachment? And then while you're doing that, where you're questioning the claimant or the judge is, all right, I'm going to direct them to produce proofs. You know, the judge should then say to them, are you currently working? No, I'm not. All right, I'm going to direct you to get proofs. And then the second question you should ask is, and Judge, before LWIC is found, we want to ask him about his residency status. Right? Those are the two things that we should be doing in every case at classification. All right. Final reminder, the RFA2 change is coming, and it is only now 2 weeks away or so, roughly. Okay. Looks like most of the people in this room, because you're my go-getters, right? You're here. You took your RFA training. Everybody else, make sure you take it. That's this new form. We're going to have some advice and best practices for how this needs to be filled out. It's also going to change the way we're going to be instructing our clients, because it turns out in order for us to fill this form, our clients have to correctly identify us as a party of interest. And we've had some situations where our clients have identified us as the employer, as the carrier. You know, we're not correctly listed inside of eCase. So this is going to be very important for us to get that correct. And we're going to have to do a lot of client training to make sure that they understand how this is intended to work. Before this rolls out on March 20th, you will be getting some direction from us as to exactly how this is going to work with our system, which ones need to be certified, not certified, and then again, how to fill out electronic form. This training is mandatory for everyone. Let's not forget it. Let's remind our paraprofessional or the attorney we work with, hey, did you do this? Let's make sure we do this. All right, other ways to learn. We have a newsletter. Christian has an amazing podcast. For those of you who are participating in our mock trial program this month, you may have just received some of the heads up about some of the topics and the arguments to be raised and may be litigated in our mock trial program this month. So, just think about that. That's it. Please sign out of the presentation and please rate and tip your speaker. Thank you.